Can the testimony of a deceased victim be used against an absconding accused? When can a juvenile be tried as an adult in heinous offence? Do custom officers have the power to arrest in smuggling cases? Supreme Court settles the law. On 17th July 2026, the Supreme Court in the State of West Bengal versus Kader Khan restored the trial court's order permitting the prosecution to rely on the deceased victim's testimony recorded during the earlier trial against an accused who had absconded for several years. Setting aside the Calcutta High Court's decision, the court held that under Section 299 of the Code of Criminal Procedure, now Section 335 of the Bharatiya Nagrik Suraksha Sanhita 2023, a formal judicial order declaring an accused absconding is not mandatory. What is essential is proof that the accused had absconded and there was no immediate prospect of arrest when the evidence was recorded. The court observed that allowing absconding accused persons to escape the consequences of crucial evidence would defeat the purpose of criminal justice and encourage deliberate evasion of trial. On 21st July 2026, the Supreme Court in X versus State of Bihar Anr held that a child above 16 years of age accused of murder under Section 302 of IPC can be tried as an adult as the offence falls within the category of a heinous offence under the Juvenile Justice, Care and Protection of Children Act 2015. The court clarified that life imprisonment under Section 302 IPC amounts to minimum prescribed punishment, making the offence ineligible to be classified as a serious offence. It further ruled that while an appellate court may seek assistance from psychologists or medical experts during a trial, such assistance is discretionary and not mandatory. The judgment also laid down comprehensive guidelines for Juvenile Justice Boards on conducting preliminary assessments, emphasizing a careful evaluation of a child's mental and physical capacity, understanding of the consequences of the offence, and the circumstances surrounding the alleged crime before deciding whether the child should be tried as an adult. On 21st July 2026, the Supreme Court in Union of India versus Messrs. Kanishk Steel Industries Limited and others reaffirmed that custom officers possesses statutory powers to investigate, arrest and prosecute individuals involved in offences under the Customs Act 1962. The court held that such officers are not police officers for the purpose of Indian Evidence Act and therefore confessional statements recorded by them under the Customs Act are not automatically inadmissible. Stressing the need to effectively combat economic offences and smuggling, the court observed that customs authorities perform a specialized investigative role distinct from the regular police and are empowered to take necessary enforcement action in accordance with the law. And that's all for this week. Stay tuned with Law Times for more such insightful judicial updates. Thank you.